Hello everyone, this is Enzamam and welcome to Enzamam Study Hub. We already have discussed the basics and many other aspects of right to property in earlier parts, and this is the third part of the topic right to property. And in this part, I will provide you with a detailed background and a chronological concept of right to property. How has it been evolved? We have already discussed the fundamentality of right to property in the original constitution under Article 19, Clause 1 and Subclause F, and the Article 31, Clause 1 and 2. Now let's see what do these articles say about right to property. The first article was Article 19, Clause 1 and Subclause F. It says that every citizen has the right to acquire, hold and dispose of a property subject to reasonable restriction under public interest or interest of scheduled tribe. And the second provision, that is Article 31, Clause 1, it says that nobody can be deprived of his property except by the authority of law. And the third and the last provision is the Article 31, Subclause 2. It says that the government will acquire property only for public purpose or in public interest, and the compensation must be given to the deprived person of the property with a declaration of court, that is, the compensation must be given with a full market value. So when the court declared that the compensation has to be given in full market price or full market value, so the main problem here with the government is the compensation. That compensation has to be in market price. But the government of India was unable to provide the full market value of the compensation due to the deficient nature of the state exchequer. So the government started to weaken the provision of Article 31, Subclause 2 gradually. And the first step was taken to amend Article 31, Subclause 2 by 4th Amendment Act 1955 by Nehru government. Previously, Article 31, Subclause 2 spoke about the compensation that must be given in full market value. But the amendment changes its provision, that Article 31, Subclause 2, now it says that the given compensation cannot be questioned in any court of law about its adequacy. After amending Article 31, Subclause 2, the government thought that the problem is solved, but yet and still people were going to the court because it was still the fundamental right of the people. And again, Article 31, Subclause 2 was amended by 25th Amendment Act 1971 by Indira Gandhi government. And in this new provision in Article 31, Subclause 2, that the word compensation was replaced by the word amount, but yet the problem had not been solved. And after all these happenings, finally the last Amendment Act of Right to Property was held by 44th Constitutional Amendment Act 1978 by Morarji Desai government from Janata Party. It removed right to property from the list of fundamental rights of Part 3 and made it a legal right under Article 300A. And what does Article 300A say about right to property? Article 300A states that no person shall be deprived of his property save by the authority of law. The words and the provisions of Article 300A is as same as it was mentioned in the original constitution, that no person shall be deprived of his property except by the authority of law. It was the exactly mentioned, but the difference is that previously it was a fundamental right, but in the last amendment it is removed from the list of fundamental and made it a legal right. And in a span of time there were many exceptions to the provisions of right to property were made by different government, and some exceptions are still valid to the provisions of right to property. So I will discuss the exceptions that are still valid to the right to property, or exist today or still valid today, in the next part. So till then, take care of yourself, and if you have not subscribed to my channel, kindly subscribe to it, and if this video is informative and helpful, share it with your friends, and have a good day.